Thank you very much. I appreciate the opportunity to be here tonight. I am delighted to be with you here on this occasion as we celebrate our Constitution. A Constitution which has provided a sound and enduring foundation for ordered liberty in our land. A Constitution which has made it possible for us as Americans to live under the rule of law. I cannot speak about our Constitution and the rule of law without feeling some emotion, because so many of the blessings that we enjoy in our country are possible only because we live under a Constitution and we live under the rule of law. Now, the idea of the rule of law and the idea of constitutional government are closely intertwined. I recently gave an address here to the Federalist Society. To those of you who were here for that, I apologize. This was going to cover some of the same ground. But these ideas related to the rule of law are so integral to the ideas of constitutional government that I felt they were appropriate to repeat on this occasion. Now, it is safe to say that the idea of the rule of law has been central to the American understanding of our identity as a nation. Our Constitution stands as the preeminent symbol of the rule of law. As the first Chief Justice of the United States famously remarked, ours is a government of laws, not men. Americans have long recognized the Constitution and the rule of law as a bulwark against arbitrary power and anarchy. The rule of law protects us from one another, and it protects us from those who wield the coercive power of government. The rule of law provides a predictable legal environment in which people can rationally plan their lives and obtain redress for legal wrongs they suffer. Where the rule of law prevails, everyone is equal before the bar of justice. The laws, which are publicly promulgated and known, are administered uniformly and impartially. Everyone is subject to the law. No one is above the law. And the most humble and powerless can obtain redress against the most exalted and powerful. Even the government itself and the officials of the government stand in subjection to the rule of law. Now, those are the hallmarks of the idea of the rule of law. Today, as I am here, I'm the Chief Justice of Florida, and I want to make some brief comments about the role of judges in the rule of law under our system of constitutional government. Now, this is my first point. The vitality of the rule of law and constitutional government depends upon an independent judiciary. Without judges, there can be no rule of law. Without judges, there can be no constitutional government with its characteristics, checks, and balances. The rule of law can be implemented only where there is a fully functioning system of courts in which impartial judges preside. And the judges who preside in such a system, if they are truly to be impartial, must not be mere creatures of the government. They cannot serve at the mere pleasure of either the executive branch or the legislative branch. If the government and its officials are to be held accountable before the bar of justice, the judges on the bench must be able to act independently of the government and its officials. It is also essential that the people have reasonable access to the independent judiciary. In order to enjoy the benefits of the rule of law, people must have the ability to come to court and obtain justice without unreasonable delay. Backlogs in the court system thus undermine the vitality of the rule of law. It is undoubtedly true, as it is often said, that in many cases, justice delayed is justice denied. An independent judiciary does the litigant no good if the litigant's case cannot be heard. Now I'll move on to my second point, which is this. The vitality of the rule of law and constitutional government depends on the disciplined commitment of judges to the rule of law and to the Constitution. The rule of law can prevail only where judges recognize that the impartial administration of the law is a matter not only of institutional integrity, but also of personal integrity. A matter not only of official duty, but also of moral duty. The rule of law depends on judges who are always mindful of the oath they have taken to uphold the Constitution and the laws. And it depends on judges who never forget that all past connections, friendships, allegiances must be put aside, and the judge dons the judicial robe. Ultimately, the judge who is faithful to the rule of law and to the Constitution must be willing to be deprived of office if that is the consequence of acting to uphold the law and constitutional government. And always the judge must decide every case without any consideration of the impact the decision may have on the judge himself. Such self-sacrificing service requires consistent self-awareness and discipline, a commitment to live by the rule of law, a commitment to always remain faithful to the Constitution. Now this is my third point. The vitality of the rule of law and constitutional government depends on judges having a proper understanding of the judicial role. Now this point is related, obviously, to the point I just made. But what I wish to emphasize here, which I think is very important, is that judges must understand that the rule of law does not mean the rule of judges. Judges are essential to the rule of law, but they are not the incarnation of the rule of law. Judges in their judging are themselves subject to the law. Where the rule of law prevails, judges are the servants of the law, not the masters of the law. And there's nothing more important for a judge to understand and to live by. The judge who understands the proper role of the judiciary under the constitutional system of separated powers will always operate under a sense of constraint and with an attitude of restraint. The judge will understand and yield to the constitutional limits on judicial power. The judge will always remain focused on the text of the governing provisions of law, whether that be in the Constitution itself, in a statute, or a rule, and on the pertinent judicial precedents. The judge will understand that she is a person who acts under orders and must be willing to obey the commands that have been issued by others as they are reflected in the governing law, even when those commands are disagreeable or seem unjust to the individual judge. The judge will not ask, "What do I think?" or what do I want? But what does the law say? What does the law require? Now this point has never been made better or more succinctly than it was by Alexander Hamilton in the Federalist Number 78, where he observed that the judiciary, and I quote, "may truly be said to have neither force nor will, but merely judgment." According to Hamilton, if judges, and again, I quote again, should be disposed to exercise will instead of judgment, the consequence would be the substitution of their pleasure, that is the judge's pleasure, to that of the legislative body. The vital distinction Hamilton thus drew was between the exercise of judgment, which is the proper judicial role, and the exercise of will, which is judicial usurpation. Now, judgment is defined in Webster's 1828 dictionary as the faculty of the mind by which man is enabled to compare ideas and ascertain the relations of terms and propositions. Will is defined as disposition, inclination, or desire. So a judge is exercising judgment when he looks at the law and he looks at the facts and sees how these things how the facts must be analyzed in terms of what the law says. Judges exercise judgment by looking to the law. They exercise will by looking within themselves. One time I heard a judge who was being interviewed for a judgeship say that when asked, "Well, what's your judicial philosophy? You know, in a tough case, how do you go about deciding it?" And the judge said, "Well, I just go with my gut," which that's not the right answer. That's not the right answer. You have to go with the law, and if it's a tough case, you have to do your very best to figure out what the law requires. But that all has to remain the focus, and it can't be the judge's individual sense of morality or the individual policy preferences of the judge. It is about something outside the judge, embodied in the law. So judgment is anchored in the commands of the law, and will is anchored in the judge. The exercise of judgment is the lifeblood of the rule of law, while judicial willfulness is the enemy of the rule of law and the enemy of constitutional government. So the vitality of the rule of law and constitutional government depends upon judges who can discern the difference between judgment and will. As Alexander Hamilton recognized, without that understanding, no judge can faithfully serve the law. Without that understanding, no judge can faithfully uphold our Constitution, the Constitution we are here to celebrate today. So I thank you for listening to my remarks, and I'll be happy to answer your questions. I especially thank the people that had to listen to them twice.
If you have questions, Justice Canady, if you would just stand up and state your name and you're with the organization. Justice Canady, take the questions.
Sure.
My name is Ben Burton, born and raised in Polk County. So I followed your history for a number of years. I'm very grateful that you are now the Chief Justice.
Thank you.
Tremendous experience. It will be a great benefit to the court and the Civics law. My question is, what remedy, if any, is there available when a justice, whether it's Judge Supreme Court or otherwise, tries to legislate for revenge, particularly in trying to incorporate foreign statutes and foreign judicial opinions into the opinions of the United States Supreme Court or other courts?
Well, as to the remedies for the judicial conduct of judges, it depends on the level you're talking about. Effectively, at the federal level, there really is no remedy for that because judges are life tenured. They serve for life unless they are impeached and removed from office. That, of course, is a very difficult process. Actually, that is a process that is going on right now with respect to a judge from Louisiana. I don't think it's over yet. But I was earlier this week, I was watching the beginning of the trial of Judge Porteous, a federal district court judge from Louisiana, who has been impeached by the House of Representatives and whose impeachment trial was going on in the Senate. So that has happened, I think, maybe only 14 times in the history of our country. And that has been, I think, if not in almost all cases, for something that either was criminal or came close to being criminal. It has not been used because of the view that someone exceeded the proper bounds of the judicial role. Now, that's at the federal level. So when you're talking about the U.S. Supreme Court, that's the lay of the land there.